Hi, everybody. This is Paul Hitchcock at Barth Calderon, and it's just coming up on 10 o'clock, and we've got some great people jumping on here. Thanks for joining the live forum. Brad, are you there?
Yes, I'm here, Paul. Thank you.
Great. All right. Well, I'm traveling here, and so, if there's a little noise in the background, my apologies. But again, we have some great people on board, and a couple things before we jump into this is that we're recording this, so we'll send out a recording to all people who registered. We know there's some folks that can't make it, but let's jump right in. And again, thanks for those of you who have not been on one of our forums before. Brad is one of our attorneys, experts in estate, business, and asset protection planning, and one of our top speakers across the country to many incredible groups. So some of the content here today is what Brad delivers in his workshops. So really excited to get you some access here. So we've got questions that were sent in prior, Brad. I'm going to start running through some of those. And for the audience members, please feel free to start typing there on your screen questions, and we'll start grabbing those along the way. So first question, Brad, is deals with estate planning.
Yep.
And John is asking, he said, I heard estate planning avoids probate. Mm-hmm. What is that all about, and how does that work?
Okay, great. First of all, everyone, thank you very much for taking the time out of your busy day to spend some time with both Paul and I. We found that this open forum is actually a very, very well received format, and it's good for both us, for Paul, as well as for me, the speaker, to make sure we address the questions that are top of mind to people out there in worldwide. Okay, so the question that you have here is about estate planning and probate avoidance, and you hear this a lot when estate plans are advertised from attorneys, or even just as a general common knowledge. And what I have found over the years is that that's not entirely an accurate statement. You hear a lot about have an estate plan and avoid probate. And what I mean, it's not a full, complete sentence or statement, is because having the estate plan is a necessary component toward the objective of avoiding probate. Okay, so you have to have, as part of an estate plan, a trust, and typically it's a living trust or an inter vivos trust, a revocable trust, which most people are familiar with. But that trust will only help you avoid probate to the extent that it's funded. Okay, and what we mean by that is that you can have an estate plan, you can have a power of attorney, wills, and you can have even a trust. But unless you transfer your assets inside that trust, those assets still remain in your individual name. And what probate is, the way in which you dispose of an asset that's still in the name of a deceased owner. And so the whole point of having a trust is to transfer the asset into the trust, so the trustee is able to dispose of that asset for the benefit of the beneficiaries, you see? So it's not just have a trust and avoid probate, or have an estate plan and avoid probate. You got to make sure the trust is funded. So I think a more accurate statement, Paul, is if you have a properly funded trust, then your estate plan will avoid probate. Okay.
Right.
I think that's more accurate. Okay.
And the funding thing is, I hear you talk a lot about it, is what's important is people actually, when they do their estate plan, a lot of them later on in life forget to fund the plan, because maybe they buy another piece of property or whatever the case is. So do you see a lot of that happening?
Absolutely. And that's one of the main reasons why we have people come in for reviews every so often, because signing of the documentation is not the end of the estate planning. It's only the end of the beginning of the estate planning. All you've done when you sign the documents is you create the bucket, I refer to it, the bucket or the box to receive the assets. So then you have a continuing, for the remainder of your lifetime, you got to put assets inside that bucket, right? So it's not just a matter of it happening one time. It's an ongoing exercise throughout the remainder of your lifetime for those assets to avoid probate. And that's also why when we do the reviews, not only are we looking to see, do you still want your fiduciaries? Do you still like your sister to make healthcare decisions for you? Are your kids older now as far as their distributionary provisions? But also, let's do a quick audit of your assets. Let's make sure all the assets are in your trust so you do get the benefit of the probate avoidance. So it is an ongoing exercise.
Okay. All right. And the other issue is I've heard you talk about too that a will goes hand in hand with the trust, because if you do forget to fund the trust and you pass away, the will is there as a backstop. Is that how do you
Yeah, that's right. Yeah. So what you're referring to is what's called a pour over will. Because again, if our main vehicle for distributing assets is going to be our trust, and if we have assets that are not in trust, these assets are subject to probate. We just talked about that. These are probatable assets. These are non-probatable assets. Well, the assets that go to probate, how do we make sure that they're working in concert with the plan? If this is our primary estate distributionary tool, this is where we put all the protective provisions for drug and alcohol, special needs, asset protection, multi-generational planning. If this is our main tool, how do I get the asset that I failed to put in during my lifetime inside here?
Right.
Well, if you pass away still owning it, you obviously can't do it because the owner is now deceased. Those assets go to probate, and the probate court looks at your will. And your will, your last will and testament, at that point in time, it gives instructions to the probate court. Your Honor, when you finish the probate process, take these probatable assets, put them inside my trust, because I want the trust to control it. So a will is a necessary component to having a trust. They work together. Like you said, it's kind of a fallback plan. But if you're proactively planning, everything should be inside your trust, and there should be no need for the will to ever speak in probate because there's no probatable assets. But it's always there to make sure your assets are all working in concert, because the trust is the main testamentary distributionary tool.
Okay. All right. Great stuff. So here's another hot question. And this is something that a lot of us are dealing with. It revolves around elderly parents and kids who are the trustee for the parent.
Right.
Something happens to the parent, they become incapacitated or pass away, and all of a sudden the kid is the trustee.
Right.
So the question is, what are my responsibilities, and what is that all about? What should I be looking for?
Okay. Yeah. Paul, that's a great question. And do we have enough time to answer this question? I could speak for days on this because it's just one of those areas that it's so case by case specific. But let me first define what the issue is that you're addressing, and then we'll talk about the particular roles and why it's such an important position. So first of all, you're talking about the role of a trustee, and in your scenario, and we do this all the time in drafting, you're asking somebody, when you become incapacitated or when you pass away, who is it that you want to take on that role of mustering up the assets, netting out the expenses, paying off your taxes, et cetera, and then either distributing or administering those assets for the benefit of the beneficiary. That individual is the trustee. And if you look at the main component, the main word of the word trustee is trust. Somebody has to be a responsible individual to be able to do this. Okay. So all of a sudden someone becomes incapacitated and they pass away and they get this notice, oh, you're the trustee of your parents or your siblings' trust, and they have no idea what to do. It's very, very complicated. It's quite a daunting and comprehensive job. And the difficulty about it, Paul, is that it's a fiduciary duty, meaning that you have a responsibility to muster, administer, protect, and preserve assets for the benefit of a beneficiary. And there's no higher fiduciary duty in the land than that of a trustee for the benefit of a beneficiary. So it's a very, very high liability, high responsibility case. As a matter of fact, I like to say that a trustee themselves should take the copy of the trust that they have, and they should actually write themselves 2 copies. They should write it out twice, so they have it so embedded in their brain that they always have a copy of it with them physically, and they always have a copy of it in their mind, because it's just one of those things that you have to just know the rules for that. And because you have to, again, administer and hold those assets for the benefit of the beneficiaries. And what happens is they don't know what they're doing. You cannot use the trust and the trust assets for your own benefit. You can't use this to amass your own wealth. You can't have unreasonable compensation. You're using this, you are responsible for the benefit of, again, the beneficiaries. I keep on saying that because a lot of people think that, oh, it's my stuff and it's just upon my pure graciousness I'm going to give to the beneficiaries. And that's not true at all. It all goes back to having someone who understands what they're doing, or have someone who knows that they don't know, but yet have enough sense to seek out counsel to help them with the job, okay? So as we've mentioned before in previous recordings, our office not only provides trustee counsel, but also trustee coaching to make sure that process kind of moves along. So you have understanding the position. You got to have someone that has experience and accountability for what they're doing. They have to have a commitment to do this because it's a complicated job. And the first time it gets difficult, either because of the accounting, the mustering of the assets, or dealing with the beneficiaries, you don't want that person just throwing in the towel, either just distributing the assets outright, which kind of defeats the whole purpose, or just giving up and you have your second or third or fourth choices now having to step up. And you chose somebody as a trustee because you think they're the best person for this. You don't want them just throwing in the towels. You want to make sure that they have at least a level of commitment, or someone that will at least seek out help to make sure they maintain that commitment. Longevity and continuity, you want to make sure someone is able to keep that trust going, because sometimes they go for long periods of time, whether it's 20, 30 years, or sometimes even multi-generational. And somebody that's objective. This is also a big part of it about who you should properly choose. Is having someone that doesn't necessarily have a favorite person among the class of beneficiaries, simply because a trustee really shouldn't have a horse in the race, as I say. They really should treat everybody equally and relatively objectively, and they got to, again, follow the terms of the trust. So that's just kind of a scope of what the job is, and people do get overwhelmed with it. They don't communicate effectively. They clam down. They just neglect the responsibilities because they kind of get this thrusted upon them. So wait a second, I'm busy with my own life, Paul. I have my own kids. I got my own business I'm running. Why am I dealing with your business? Why am I dealing with the sale of your property? Why am I dealing with your kids and their tuition costs and paying their bills? I got my own thing going on here. So it's very complicated. And that's the challenges that we incur when someone just wakes up one day and says, oh, by the way, you're now my trustee. So either you don't accept the position from the get-go, which again is kind of not always a good thing. But if you do accept the position, just hook on with professional assistance. Get trustees counsel, get some trustee coaching. And so that way you can do the job that the person thought you were the best person to do the job, right? So I guess a long way of saying it's a big responsibility, and just have some help in getting that done, because ultimately everyone is for the better in that regard.
Isn't part of that equation protecting the parent's assets from a long-term illness too? As a trustee, I mean, that can be a drain on the parent's assets.
Yeah, you bet. There are. We have Medicaid, Medi-Cal here in California. There are certain things that can happen with regard to medical expenses and long-term care expenses. But I think it just kind of goes down to one of the general objectives of a trustee is to protect and preserve the trust assets for the benefit of the beneficiary. Whether that beneficiary is the trust makers themselves because they're still alive, they're just incapacitated. Again, you're holding it and preserving it for their benefit, meaning you may have to do some maneuvering with the assets for that preservation purpose, or you're protecting and preserving it for the contingent beneficiaries, which traditionally is going to be the kids, right? Kids or the grandkids. So if the kids themselves are spendthrifts, the kids themselves have drug and alcohol issues, the kids themselves are, have a special needs issues. Again, protecting and preserving the trust assets is one of the primary roles of what a trustee does. Oh, Paul.
Well, no, I got, yeah. Okay. So one of the issues I'm looking at, my question came in here. Someone just emailed in about, and you just touched on it, a special needs trust.
Right.
And they're mentioning that their kid is 25 years old. They own some property. and they're worried about their kid who's email here says they're doing better, but how do you account for a child in this situation where they want to, you know, help a kid out long term, and
right.
after they're gone, what do they do?
Right. So what you're referring to is what's called a special needs trust. And this is, again, one of the benefits of having an estate plan and working with an advisor that's familiar with these things. The rules for special needs trust are very, very complicated, and the accounting rules are complicated as well. But it's something that can be done within the trust document itself. There typically are two different types of special needs trusts. You have a traditional, like I think with your clients. I mean, the question is if I pass away, how do I have the estates held for the benefit of my child who is currently receiving government aid? And then you have those people who are receiving government aid now while they're alive, and you want to be able to contribute to an existing lifetime special needs trust. So there are testamentary created special needs trust, or we create one during lifetime, and you're able to fund it and still use the funds for the beneficiary during your lifetime as well as their lifetime.
Is a special needs trust separate from your own living trust? So it's two documents?
Yeah, again, depends. If you set one up during lifetime, like a litigation-based special needs trust, then absolutely, it's a whole separate entity because you yourself haven't passed away yet. So your trust isn't creating one. You create one today. It's its own separate entity that you can actually fund and operate today. Most cases with clients, they say, well, if I pass away, I want to make sure my inheritance goes to my kids, but that inheritance doesn't affect the disqualification from them receiving government benefits. It's very simple. If all of a sudden your child receives $500,000 of an inheritance, the government sits back and says, well, now that the child themselves has $500,000, why would we put them on the public dole? Now you have your own source of funds. But when those funds are completely consumed in their care, okay, now they can requalify because now they're under a social welfare program. Okay, got it. So the government itself acknowledges that what it provides isn't sufficient beyond its basic, food, clothing, and shelter, okay? So it allows a parent, typically a parent, to create a side pot. We call it a special needs trust. To receive an inheritance, in my example here, $500,000, which is used to supplement what the child is already getting from government benefits and most importantly, without disqualifying them from receiving government benefits, right? So in the first example, you just list your kids as a beneficiary and they're receiving government benefits, boom, the good thing you did disqualified them. With a special needs trust, you're able to inherit in a special trust for them, which is used to supplement what they're already receiving without disqualifying them for receiving. Huge difference, very, very important, not only for the beneficiary, but also important for the parents to preserve, again, back to your previous question, to preserve all that they work so hard to accomplish during their lifetime. So special needs trusts are very, very important and, and necessary components for those types of situations, yeah.
Well, here's a follow-on to that. Let's say your kid is not special needs, has special needs, and you're passing assets to your kids. Mm-hmm. Again, I heard you mention in your workshops about an asset protection trust to protect your inheritance from the potential future creditors of your kids.
Right, right.
So what's that scenario about?
Okay, yeah. So basically, you have to understand, and I'm going to get a little technical here. You have to understand that when you put an asset in trust, you're effectively breaking the asset down into two different components. The legal component is held by the trustee, right? So you have a trustee holds the asset, and you have a beneficial component. We call it a legal interest and a beneficial interest. So when you put an asset in trust, you've now bifurcated the interest between legal and beneficial. Now, in most cases, it's the same person, okay? You have a merger, it's the same person. But if in a properly designed estate plan, when you're trying to get the wealth preservation provisions that you just mentioned, I call them wealth preservation provisions for your kids, you need to split that interest. So typically you would have a third-party trustee, let's say you have a professional trustee, they now own the legal interest for the benefit of the kids who own the beneficial interest. And so long as the asset is held under that arrangement, or it's held in trust for the kids, The trustee, as I mentioned, can only use the funds for the health, education, support, and maintenance of the beneficiary to protect and preserve the trust assets for the beneficiary, not the beneficiary's creditors. As a matter of fact, the documents should have what we call a spendthrift clause or an anti-alienation clause, which specifically prohibits the trustee from ever using the funds for the benefit of a creditor, right? So that's how it works, but it has to stay in trust. So when you design these family wealth preservation provisions in your estate plan for second generation asset protection, they need to be held in trust. So that trust can go on for 20 years, 30 years, for the kid's entire lifetime. And so long as it's held in trust, Paul, you've effectively created a domestic asset protection trust for your kids, which is amazingly powerful. The problem is that if you just give it an outright distribution, just an outright distribution, okay, my kid's older enough, he's old, just he's 40, okay, just outright, he's responsible outright. And this is when there's no separation. Once you give it to them, it's their asset. And then when it's their asset, it's subject to the claims of their creditors. So trying to get the asset protection component, the family wealth preservation component, those assets need to be held in trust. Now, it's not a separate trust, Paul. It's the same trust that mom and dad created. It's just how is it designed on second death, right? So you don't have to create separate trusts here. They automatically are created from mom and dad's plan looking down. So it's mom and dad's level we have to put these provisions in. So when they pass away, it's held in these special family wealth preservation structures for the beneficiaries, right? So it's all at the design level.
Yeah, and again, I heard you mention that this is a great strategy for kids who are in high-risk professions where they get sued all the time, doctors, or professionals.
You bet.
And even divorce. I mean, divorce is so prevalent today. Imagine your kid getting divorced.
That's right.
And your inheritance is,
Right. Yeah. So let me kind of address that, because it's always a big point, not only in common law, community property states like here in California, but even in common law states. When you receive an inheritance, that inheritance is separate property, and it stays separate property until you do something with it. You commingle it with other assets. You put it in joint accounts. You do something with it. And the nice thing about these wealth preservation provisions, because the title is still held in the trustee, the beneficiary never got legal ownership. They just have use and enjoyment for their lifetime. Since they don't have legal ownership, it's legally impossible for that asset to become commingled with other marital assets. Therefore, it stays in a separate property silo. This is how you keep an inheritance separate property. So if the kids get a divorce in the future, they may divide their community property, they may divide their joint property, but the separate property silo that you left them will always go with your child. They get the community 50-50 and 100% of their separate property because it never got commingled. Again, another very important part of keeping an inheritance separate property from reaching your future ex-daughter-in-law or son-in-law's grab, right? Very, very important.
Okay. Well,
I find that to be one of the main motivating factors for most of our clients. Oh, my kids are perfectly financially responsible, right? I mean, they themselves are lawyers and doctors, like you said. So it's the asset protection thing and the potential future divorce thing. That's what motivates most parents in creating these longer term holds. And it's not that they don't trust their kid. They're just giving them this awesome asset protection opportunity, right? That's all. That's built into this wealth preservation trust.
Right. No, good stuff. Well, here's kind of a follow-on, a question from the listener is, how would you protect assets if you have a spouse who is ill and is worried she will spend down all of the retirement accounts on medical care? Can they move assets into a trust to qualify for Medi-Cal?
That's right. Yeah. So there's Medi-Cal planning and Medicaid planning. It itself is an entire area of practice, right? So we have here in California what are called Medi-Cal Asset Protection Trust. You've heard them referred to as Medicaid Asset Protection Trusts. There are ways which you can spend down assets and preserve those assets for the benefit of a well spouse or for the benefit of the family, and yet still qualify for the government aid. Okay, there may be some penalty periods on transfer that you're responsible for, but many times that penalty period amount is substantially less than what you actually got out of the estate. Now, this is actually a very complicated area, and you have to work with someone who's kind of specializes in this practice area. So mostly it's elder law attorneys work with this. We do it here in our office. It's not my particular area. The office does provide for, we have people here, but also in your particular state, you want to seek out someone that has particular skills and knowledge of this area. Very technical area, but yes, it is a legitimate planning area, legitimate field of law under elder law.
And it's a big deal today. Obviously, for this listener, it's a big deal for a lot of people because
right.
people are living longer than ever before.
Right. Yeah.
The doctors can keep them alive longer, but they can't keep the illnesses away.
Yeah. Yeah.
And it's expensive.
Yeah. That's right. That's right.
All right. Well, here's another great question. This is from Julie, and this is, what is the process to add properties in an LLC into an existing trust?
Okay. If I got the question correct, you're taking an LLC and you're putting that LLC into the trust. I think it was like, there you go. You're taking the LLC and you're putting the LLC in trust. It's important to understand that the LLC itself is what in this question, that's what gets funded. So if you have a rental property, a very simple example, you have a rental property, you want to transfer the property into the LLC, right? So because that's your asset protection tool. So you put the property in the LLC. Now that you have this LLC, you don't want it to be a probatable asset because the membership interest, the membership certificates are issued in your name. Now you want to take that LLC and you want to put it inside your trust. So the LLC goes inside your trust. Now the trust is not the asset protection tool. The LLC is the asset protection tool. The trust is the estate planning, the probate avoidance tool. So if I understood the question correctly, they're not funding the trust, they're funding the property into the LLC, and then the LLC needs to sit inside the trust. It's kind of like those Russian dolls. You got the big doll, the little doll, the little doll, little, right? The big doll on the outside ultimately is your trust. And then all those other little dolls may be LLC 1, 2, 3, corporation 1, 2, 3, limited partnership 1, 2, 3. The trust itself is your ultimate owner for estate planning and succession planning purposes.
So great. And Julie, if you want to follow along with that question, feel free to type something out. But Brad, that begs the question then, we're assuming here an LLC is a great guard for a rental property.
Right.
What does it guard against? And again, maybe it's an inside versus outside liabilities.
Yep.
Quick touch on that.
Yep, sure. So when it comes to LLCs, and this is an LLC that's set up in some of the more asset protection oriented jurisdictions, that LLCs provide liability protection and asset protection in two different directions. And most people are familiar with the limited liability characteristic of an LLC. Again, just using your example of the rental property, someone slips and falls on the property, you don't want to be personally liable. You don't want to lose your house and your brokerage account, everything you've worked so hard for, because someone slips and falls on your property or there's a fire or something. So that LLC provides a limited liability tool. They can't get to you personally because it's held in this entity. So and you said it, this is the internal protections, the activities happening inside, you're protected from personally. So also LLCs provide asset protection, meaning you're an owner of an asset. Well, you yourself present the liability to the asset, because what if you run a red light and hurt somebody? Or what if your spouse runs a red light and hurts somebody? Well, you own this asset, and everything that you own is subject to satisfaction to the claims of your creditors. So you also want a tool that prevents someone from reaching in the LLC and taking the asset. I like to say you want to close the cookie jar. You don't want someone who's reaching into the cookie jar and taking out the cookies. So LLCs provide dual protection. One, they protect you from the activities on the land, the slip and fall scenario, and set up in a proper jurisdiction, they also protect the asset from your personal creditors. So that's kind of, I think, what you're asking me about, what we call the internal protection as well as the external protection.
Right. Yeah. Sorry, the noise in the back. But another question here is blended family planning. This comes up a lot. And the question is, I'm in a blended family. We both have kids from separate marriages. What should we be looking out for?
Okay. So blended families are, as you can imagine, are complicated, and we deal with them a lot. And it's one of the plans I love doing the most, because you get the biggest benefit ultimately going to the to my clients, because everyone wants to make sure that their family is taking care of their kids. So you may have a second marriage and the new husband and wife love each other and they both got kids from a prior marriage, but the kids don't necessarily love their new mother-in-law or stepmom or stepdad so well. So you're trying to find a proper balance between how do the spouses take care of each other, but yet preserving the assets for the kids down the line. And so the first thing you really need to do is just have a good understanding of what the assets are. So hopefully they're coming to us with some form of premarital agreement. That certainly helps a lot, because now we've characterized the assets. We know what assets he's bringing in. We know what assets she's bringing in. And it certainly helps us with trickling it down from a separate property versus community property, a separate property versus joint property. So if you have a premarital agreement, and if not, we would help to create what's called a post-marital agreement, characterizing the assets afterwards. Then you can just have a his plan and a her plan, two trusts, his trust, her trust, because there's no joint assets. And so typically what I wind up doing is you wind up having lifetime income and maybe some principal invasion. So if one spouse passes away, the assets, at least the income, is held for the benefit of the surviving spouse. So they have wealth replacement. They don't have to, they can maintain their normal standard of living, right? So but then when the second spouse passes away, then the principal passes down to their individual kids. So we need to know, if you just have separate property, either via premarital or postmarital agreement, we only need to have two trusts. Sometimes, however, not only are they bringing in assets that are kept separate, they also have assets they acquire together in a community property or in a joint property, or they both gift and they buy a new house together. So in this situation, it gets a little complicated. You wind up having a his, hers, and an our type of plan. So you have a 3-trust arrangement. So you want to make sure that we keep all the assets working together in concert, so that her assets stay separate, his assets stay separate, and the assets they have together trickle down the appropriate way. Again, a premarital, postmarital agreement is a very important component of that. And depending upon what the assets are, there's other planning tools that we may use. Insurance comes in to be a very, very helpful tool here. So if one spouse passes away, we have instant liquidity maybe for the children. So no need to liquidate the assets of the surviving spouse. There's all kinds of different plans that we have for this, but that's the general flow of a blended family arrangement. You typically walk away with a pre or post marital agreement, and then a his plan or her plan, so that the his, hers, and then the ours if necessary. And don't confuse when I say a pre or post marital agreement, because it seems to have some stigma associated with it. Especially in new marriages, they're concerned about making sure they get the proper child support or spousal support. That's not at all what we're talking about. This type of pre or postmarital agreement is strictly a matter of categorizing the characterization of the assets. Is it separate property? Is it community property? What about future acquired property? What about my income, my earnings? Are those community? Are those joint? Are those separate? They have nothing to do with spousal support, nothing to do with child support. That stuff, typically the clients still have to go duke out in a family law court if they get divorced again. But typically this is just a characterization of assets, so we have a proper flow either upon death of the first spouse, second spouse, with kids of a prior marriage, right?
Right. Okay.
Very unique circumstance, but definitely requires some good thought and planning. A lot of opportunity.
You could have unintended consequences if you don't do it right.
Oh yeah.
Big time.
Yeah.
Okay, well, here's a follow-on from Julie. I think I understand what she's saying here. This is from the LLCs and the trust.
Right.
She's a partial owner of a number of properties, each of which is in an LLC.
Right. Okay.
Her ownership of the LLC is, she says, in my personal name, but she wants to get her ownership of each LLC into her living trust.
Okay, gotcha. Okay, there you go. Okay, very easy. So she already has the asset inside the LLC. Great. Now she has her membership interest, whatever percentage it is in her name, and she wants to put that in her trust. Again, the trust funding. So first of all, you have to look at the terms of the LLC's operating agreement, because you want to see what the transfer restrictions are, if any. Every operating agreement is going to have something about transferability of interest. Sometimes you have permitted transfers, right? It just says that a member may transfer their membership interest to a trust for their benefit, their spouse's benefit, or the kid's benefit. Easy peasy. It's in the majority of operating agreements. Sometimes it's not. It's because you have what are called buy-sell provisions or rights of first refusal provisions inside an operating agreement that says if a member attempts to transfer or assign their membership interest, boom, it triggers a buyout and they take it away from them, right? That's bad. So they normally would have, you have to get the consent of all the other members or the consent of the manager or consent of the majority or something. So there's no problem with assigning your membership interest into your trust. Easy. That's the way you do it. It's called an assignment of membership interest in an LLC. But you just got to be careful that that assignment doesn't inadvertently trigger an adverse restriction on transfer. So you got to look at the operating agreement provisions to see what it is. Majority of the time, it's either a permitted transfer or everyone signs off on it because it's being done for estate planning purposes, not a control issue. But that's how you do it. Simple assignment.
Okay, which begs the point that the operating agreement is a tailored document, right? I mean, you got to really put some thought on how that agreement applies to you. Is that a fair assessment?
Yeah. As a matter of fact, when we do LLCs here in our office, since we're also a very asset protection oriented law firm, and when I do all of my documentation as well as my estate plans, I always have wealth preservation as part of my objective here. We put together some pretty tight operating agreements, right? We don't, and I see agreements all the time and off the shelf, off the internet, stuff that clients bring to me from other online services, et cetera, that just says, hey, the interest is freely transferable, whatever, just sling it out to anybody you want with no restrictions. That's a problem, right? Because the creditors can grab it, involuntary transfers. You can have it going to kids or brothers and sisters, people that you don't want to be in partnership with. So you want to make sure that you have the operating agreement properly drafted to restrict the transfer from third-party claims, from some people you don't want to do business with, but yet give it enough flexibility so it doesn't interfere with your estate planning. As I mentioned, restrictions on transfers and permitted transfers. To your point, it needs to be tailored properly. And this is just a matter of who the parties are. Is it third parties, unrelated third parties? Is it between husband and wife and kids? Is it just a single owner? So you want to, so all depending upon the nature and the ownership of the LLC, the operating agreement should allow some flexibility on the transfers for things like estate planning, right?
Yeah, because if the operating agreement is a crappy operating agreement, or you're doing something else wrong with the LLC, if you never get sued, it doesn't matter, right? It's like kind of lousy earthquake insurance. If the earthquake insurance doesn't come, who cares? But it's when something
plan for the worst, hope for the best.
Yeah, right. I mean, see, it's when something happens that these things really step up.
Right. That's right.
All right. Well, let me see. If there's a follow-on question to that one there. Yeah, no, she says thank you. That was a good one. Okay. So here's one. I don't think we got to talk about this last time, Brad, but this is a big one because we work with a lot of business owners, and it has to deal with a buy-sell agreement.
Oh, okay, great. Yeah.
Yeah, and the question here is, they're saying, I've heard that you can build asset protection into a buy-sell agreement. How does that work? So kind of a broad question. Okay,
great. Okay, so this is another one of those we could spend all day on buy-sells because it's a very, very specialized area, very narrowly tailored documents. So let's just first define what a buy-sell is for those who are listening that they may not know. Okay, so I kind of just talked about it in the previous question. So ordinarily when you have two people, Paul, let's say, for example, you and I are in business together, all right? You're a 50% owner. I'm a 50% owner. You and I get along just great. We're great business partners. You're married and I'm married. And, and I get along well with you. I don't get along so well with your wife and vice versa, right? So This way, if something happens to me, actually, something happens to you, you pass away, your estate plan, either probate or your trust, is going to say what? All of my assets go to my wife, right? Just like what mine says, all my stuff goes to my wife. If that happens, who am I now in business with? I'm now 50% Brad, 50% Paul's wife, right? Because I had no opportunity to buy that interest back. So by way of inheritance, I'm now in business with your wife. And now all of a sudden, what was a good relationship between the two of us now puts me, the surviving owner, as a difficult scenario, right? So the primary function for buy-sell agreements is to keep the business closely held. Because, Paul, truly, what is it that you want for the benefit of your wife? Truly, what you want is that you want your wife to get the benefit of your 50% interest financially, and I want continued control of the company, right? Without your wife. So a buy-sell agreement is typically nothing more than a right of first refusal, and it's typically funded by a life insurance policy. So if you and I agree that the business in question is worth $2 million, your 50% is worth $1 million, my 50% is worth $1 million. I take out an insurance policy on you, I guess it's this way, you $1 million, you take one out on me on $1 million. And the contract says when Paul dies, I receive $1 million. I must use that $1 million to buy your interest from your wife, and your wife must sell it to me for that dollar amount, right of first refusal. Therefore, everyone's happy. Your wife got the $1 million, that's what you wanted, and I got 100% ownership of the company. That's what I wanted. That's the very basics of what a buy-sell is. It's a right of first refusal, and typically on death is the most obvious example. Now, to your point, what else can we do? What else are triggers besides just death? Well, it could be incapacity. I don't want to deal with an incapacitated individual because now I'm operating with your wife via your power of attorney or through a conservatorship. So I want incapacity to be a trigger, permanent disability to be a trigger. Paul, what if you get divorced, right? You're 50%, I'm 50%. We both live here in California, community property. What happens if you get a very nasty divorce, God forbid, and next thing you know, I'm in 50% with you 25 and a hostile spouse 25. You see the problem there too? I don't want that either, right? So divorce can be another trigger. Again, asset protection for the business owners. You lose your professional license. You're convicted of a crime. Now, filing for bankruptcy. I don't want my half to wind up in the U.S. bankruptcy court trustees situation, right? What if you become insolvent? What if a creditor is trying to grab your stock? I don't want to be in business with your hostile creditor collecting off of me from a car accident or from a Nordstrom's credit card bill. All these things are triggers which result in a right of first refusal. So not only most people commonly think of buy-sells as simply a death trigger. No. It's an asset protection trigger. It's a divorce trigger. It's an insolvency trigger. It's a bankruptcy trigger. It's a incapacity. It's a moral turpitude issues like the Weinsteins, for example, something like that. All kinds of stuff could be used for buy-sell. So we really take a look at existing buy-sell agreements and how can we expand it to also include asset protection for the business owners, not just who gets the company when they die.
No, great answer. And which kind of a question I thought of as you're talking about that is, since we're talking about business partners, if one business partner is on the estate planning side, if they're estate planning, something happens in their family, incapacitation with your business partner, or they pass away, and they don't have their estate planning done, and they're going to probate, and you're in business with them, is that a potential threat on the on the business? What's the relation there?
Yeah, I'll give you a perfect example of this. This happened about 3 years ago. It's exactly what happened. One partner had an estate plan and the other partner didn't have an estate plan. And we just talked about probate. And so the 50% non-estate plan deceased partner passed away and his 50% wound up in the probate estate. And now you got the court's involvement. Things move very, very slowly. And the person in charge was like an adult son who didn't know what's going on. And you got creditors' claims inside the probate arrangement. And there was fighting among the family as to who's going to take what, and inheritance, all kinds of issues happening at the probate level. In the meantime, I'm sitting here with my other half of the business. I can't do anything because my agreement says majority rules or supermajority rules. I can't do anything because the other half's tied up in this probate mess, this sausage factory, what's going on. And as a result of that, the client lost contracts. They lost vendors. They weren't able to bid for certain jobs, all while this was going on for almost 2.5 years in this probate arrangement. It was terrible for business. Had they had that buy-sell agreement, they would have immediately been able to grab that stock and the money would have poured in the trust. Let the family fight over the money. That's fine. You got the stock. So that's a great point. Again, business partners, if you don't have an estate plan, at least have a buy-sell. That right of first refusal is critical. And preferably, you would have a buy-sell and an estate plan, right? They really work together. Buy-sell agreements and a business partner estate plannings go together like ham and eggs, right? They're necessary components, right?
Yeah, and I guarantee you that very few business owners think about their other partners' estate planning.
Yeah.
You know, kind of a personal issue. They don't think of it in terms of the business, but it's a big deal.
And listen, Paul, one of my primary concerns when I did my estate planning was to take care of my wife, right? I got proper life insurance. I made sure that there's enough income, the bills to be paid, mortgage paid. My wife, of course, my children, but my wife is one of my primary concerns. Because I'm married. It's my life's partner. Okay. Well, if you and I are in business together, Paul, you and I are married, right? We're married business-wise. And what holds us together is our business, our arrangement. So just as important as a regular estate plan to the continuity of a marital relationship for family, the buy-sell is just as important to the marital relationship of the business. Right? It's the same. You should give it equal respect because that's probably your largest asset. A lot of people are, as they say, real estate rich and cash poor, right? All the wealth in this country isn't necessarily held in cash. It's held in assets, business assets. And unless you have a source to turn that asset into cash for your family, then the asset isn't really worth the paper that that is represented by. So the buy-sell makes sure that those funds trickle down to the family on the deceased partner side, right? It's absolutely.
Yeah, it makes a lot of sense. And we just put out a blog on the unique aspects of estate planning for entrepreneurs. These are people who own businesses, and part of it is, they've got some unique things like a buy-sell to protect themselves. So good, very relevant point, which I know you and I were talking about this offline because you were helping somebody recently that, since you're mentioning marriage, another point here is on divorce. If someone's they go through a divorce, there's meaningful assets there. What are the issues involved in them redoing their planning coming out of that divorce? When do they start doing that? And what's important there? Yeah.
Okay. So that's another thing. So you do have a conflict between it. I say, when does estate planning and divorce collide, right? They aren't necessarily work well together. And I know, at least here in California, that when someone files for divorce, you have at least a 6-month, or what's called a temporary restraining order. You got things that you can't do. You can't move things around. And ultimately, when the divorce settlement agreement is executed, you have transfers of assets. The current estate plan gets revoked. The assets wind up going back to the partners based upon the settlement agreement on who walks away with what post-divorce agreement. So during that period of time where the divorce papers are filed, very technical rules as to what you can and cannot do. You can do estate planning. The problem is you can't fund it. You can't transfer the assets in because you have this TRO, this temporary restraining order, imposed on the transfer of assets, which which just makes sense. You don't want to file for divorce and have one spouse just transfer all the assets to Uncle Bob over here. You want to, again, they're trying to protect the divorce estate for the benefit of both spouses. So you can create a plan, because if you do pass away during the course of divorce proceedings, you may want the funds to flow to your now plan B. You can't do it. You can't transfer it during your lifetime, but you can do it through the probate process. This is where a will and probate is actually very friendly to us in a divorce setting, at least for that time period before you can transfer assets. I know it's a complicated answer. There's a lot to be said that I'm not saying, but I'm giving you the very broad brush strokes. But at the end of that transaction, the current marital plan typically is revoked, and both spouses walk away, and they both need new estate plans, new fiduciaries, new people to make medical decisions for them, et cetera. So as I said, there is a point where estate planning and divorce collide. Again, this is just working where you work with an experienced estate planner, because the last thing you want your estate planning attorney to do is start just willy-nilly putting plans together, start moving assets around as part of their just normal operating procedure. And next thing you know, you wind up in jail as contempt of court because you just violated a court's restraining order. So bad.
Yeah, not
Call
good.
that the law of unintended consequences.
And there's so much divorce today. It's a really sensitive topic that we're covering. So I'm looking at my email questions here. Got another one. This one has to do with I've used up my my gift exemption. I used up my gift exemption. What next? So it's kind of a broad question, but do you understand where they're going with that?
Yeah, I think I get it. Okay, so again, this is another relatively technical question. I'm glad on open forum we're getting such sophisticated questions, but the answers, I don't have the time to give the sophisticated answers that it deserves. So again, this is all broad brush stuff. You got to go back and work with appropriate counsel, and especially in a case like this, you want to have a team of not only competent legal, but also competent tax counsel. All right, so the question that's being presented is like this. Right now, under the Trump tax law, each individual person in 2018 has I think it's $11.2 million exemption. So it's a lifetime exemption. Either you use it during your lifetime or you use it when you pass away. Okay, but it's $11.2 million. And if you married, you can double it up, 22 million. It's wowee. It's a huge dollar amount. Wait to see what happens with the future administrations on where that pendulum swings on the size. Because before we were at a much lower dollar amount. So when we see people that have gifted assets away, let's say you are trying to minimize your overall estate, or you want to get assets out of your estate because you want that growth to grow out of your estate because you're trying, we call it estate freezing techniques. You want to stop the bleeding because the more your estate grows, the more estate taxes you're going to have to pay when you die. So if you get the asset out of your estate, then all the future growth is out of your estate, right? I mean, but to get the asset out, you typically have to gift it, G-I-F-T, gift it to another entity, either an individual, but in most cases, you're gifting it to a trust, special types of trusts. There are things that are called IDGITs, intentionally defective grantor trusts. We have what are called CLATs, charitable lead annuity trusts, CLUTs, charitable lead annuity trusts, unit trusts. There are certain types of trusts, kids, straight gifting trust to kids. There are certain types of trusts that you do to get the asset out and to avoid the growth inside your estate. Again, estate freezing techniques. So if you've already used up your exemption, let's say I already gave $11 million. So I only have my 0.2 left, 200,000, but I want to give away another $1 million, right? No. So, well, if I give it away, since I used up my exemption, now I'm going to get whacked with a 40% gift tax. I don't want to pay $400,000 to Uncle Sam for the privilege of giving away another $1 million of my assets. So here we have to use, as I mentioned, a couple specialized tools. There are things that are called IDGITs. There are things that are called GRATs. There are things that are called GRUTs. There are things that are called CLATs. There are things that are called CLUTs. These are all acronyms. Estate planning is like the government. We got more acronyms than you know what to do with, So charitable lead annuity trusts, grantor retained annuity trust, intentionally defective grantor trusts. These are all ways of getting assets out of your estate at a discounted rate. So although you're transferring $1 million out, it's not booked at present value for $1 million. Maybe you can book it for maybe only 100,000 or maybe 200,000 as the gift value, but you're actually getting $1 million out. It's, again, very complicated. They're called split interest gifts, where you have a retained interest and a future interest. Again, as I mentioned, this is a complicated, this is like the advanced class of estate planning. We do it all the time for business owners as part of a succession plan. And there are tools. Just because you've gotten close, or you used up your exemption, or you have assets in excess of the current exemption, we can do work for you to get those assets out of your estate and to grow, again, to keep that growth out of your estate by doing what's called an estate freeze. But sometimes we have to use some of these more advanced tools to either preserve the exemption you have left, or to minimize the actual tax hit because you've already used it up. All right. Yeah. By minimizing the present value of a future gift.
Yeah, and I know this gets technical, but I also know you've been working with some really great online sellers recently, and they've been kind of tapping into our firm about exit strategy and how to mitigate taxes and some of the tools like you're talking about now for business. Yeah. Yeah,
that's right. These are normally business owners, because it's with the exemption amount nowadays, transferring a residence really isn't. Unless you got a super expensive house, not going to breach that $11 million mark for most people.
Right. Okay, another question here. I want to get this in as we're getting close. Paul, what's the difference between a domestic asset protection versus an offshore asset protection strategy?
Okay. You got to answer 30 seconds. In 5 minutes, or let's explain this. Okay. So a big part of our practice is asset protection, or just wealth preservation. How do you protect your assets from the claims of third-party creditors, predators, liens, judgment holders, your creditors, your wife's creditors, your kids' creditors, inheritance, business creditors, etc. And so there are a lot of people familiar with the uses of LLCs. We've already mentioned those. You can use corporations. These are all limited liability tools. These are all asset protection tools: LLCs, limited partnerships, corporations. Certain forms of these trusts that we spoke about, charitable trusts, some of these estate freezing we just spoke about, can be used as great asset protection tools. You get 2 or 3 bites at the apple, because you get the tax benefit, the transfer benefit, and asset protection. Great. But when you're dealing with even asset protection trusts, there are about 14 or 17 states in the country that have domestic asset protection trust law, spendthrift trust law. Ones that come top of mind, you got Delaware, you got Nevada, South Dakota, Wyoming, Alaska, Delaware, I think Tennessee, Hawaii. These are just, and there's other ones. There's probably about 14 or so, 17 or so states that have domestic asset protection law. Now, domestically, you got a bit of a challenge, because if you take an asset I'm in California, and I put an asset into a Nevada trust for Nevada asset protection, well, we have what's called the full faith and credit clause of the U.S. Constitution, which binds all 50 states under one union, so that a valid judgment against me in California can be domesticated in Nevada. They'll look at it and say, oh, well, that's a California judgment, and it's valid, and sister state California, full faith and credit clause, and Nevada will enforce the California judgment. That's what makes us a country. Very important piece. But now you got a conflicts of law problem. Which law governs? California has an interest in seeing its judgments enforced, and Nevada has an interest in protecting its trust assets because of its Nevada trust statutes. You see the problem there? So you got this conflict of law, but because there's a conflict of law, you don't really know exactly how it may turn out, right? You still got an unsettled issue here, but it's a legit issue. So although domestic asset protection is wonderful and it works great, and remember, the main objective of asset protection is to get you to a point of settlement, many times that federal court stuff is just muddy enough to say, listen, let's just settle the issue because it's complicated, right? You just don't quite know, the unknown. Okay, now the big difference there now is you throw it into an offshore jurisdiction, right? Now you're looking at Nevis, you're looking at Cayman Islands, you're looking at Panama, you're looking at the Bahamas, you're looking at the Cook Islands. Now all of a sudden things are different. You're no longer under the American system, you're under the British system, which is very different. And you have no full faith and credit clause, right? The full faith and credit clause where California and Nevada, California doesn't exist between the United States and the Cook Islands. We call it, there's no comedy of law, and it's not comedy, ha-ha. They don't respect the laws. And these jurisdictions that we use in offshore asset protection trust, we choose them specifically because they don't enforce. There's no treaty to respect the U.S. laws. Otherwise, why would you use that jurisdiction as an asset protection haven? So here, if you were to send your California judgment to the High Court of the Cook Islands, they look at it and say, well, that's great, but that has no weight here, no full faith and credit clause here. So you got to go to the Cook Islands, hire a lawyer in the Cook Islands because the lawyer in California is not authorized to practice law in Cook Islands. You got to post a bond, by the way, in the Cook Islands for the inconvenience of the plaintiff the defendant to defend themselves. The costs go up dramatically because you got to have a trial on the issues in the Cook Islands. So you can't take the facts and the hearing and the evidence that won the case in California and bring it to the Cook Islands. You got to bring it there, right? You got to have another trial in the Cook Islands. Shorter statute of limitations period from 4 years down to 2 years. Different burdens of proof. We may have civilly a preponderance of the evidence, right, which is a 51%, and now you go to higher burdens beyond a reasonable doubt, which is like a criminal standard in a civil setting. No contingency fee lawyers. So here someone slips and falls in the store and the lawyer that's advertising on a big billboard says, here, no skin in the game, just hire me, I'll win, and then I'll take 30 or 40% as a fee, but no money out of your pocket, no risk. So it doesn't happen in the British system, right? You gotta pay your way. So the same person that may have won the case in the US has to now go to the foreign jurisdiction. They gotta hire the foreign attorneys. They gotta pay their way up front. They gotta post a bond. The laws are a little bit more narrower than the US throw it against the wall and sees what sticks. Very, very different discovery rules. Oh, and by the way, loser pays, right? So when you lose the case, you got to pay all the expenses, right? So it's a whole different ball game. And so many of my clients, we start off as a domestic structure, and we may over the years migrate them over as they become more comfortable with it to a foreign jurisdiction. Sometimes we use a combination of both. We have a domestic structure and an offshore structure, depending upon the nature and mix-up of the assets. Or because of the risks that they have, they're in a risky business. They just start off with a foreign structure because they're concerned about the lawsuit can come any day, right? Any time, you know. So you set the stuff up in advance, and that's the main difference. It's really a matter of convenience versus inconvenience, time and expense, burdens of proof, cost factors for sure. And certainly an offshore structure is much, much more likely to result in a fast and favorable settlement just because of all the things I've mentioned, as opposed to the California, Nevada type of thing. And it works domestically, but it's nowhere near as good as a foreign structure, right? But everyone's got different risk tolerances. So we got to talk to the client.
Yeah. You can go on forever about this. Brad, thank you so much. Everyone who's been on, and I'm looking, everyone stuck through this to the end. So thank you. We're going to send you the recording. Look for that, and all of you will have a chance for a complimentary assessment on any issues you're dealing with. Look for that email. Brad, thanks again, and until next time.
Okay, great. Thanks, Paul.
All right.
Bye-bye.